arbitration law was passed last year. We, in this firm, I don't believe we've had an arbitration which has gone through to an enforcement stage. I doubt many have. Typically arbitrations tend to take more than the 12, 18 months or so that has elapsed since the law came out. So it hasn't been tested yet. In theory, it should do. Now, why do I say in theory it should do? Probably one of the most significant developments in Myanmar recently has been its signing up to the New York Convention. Now, the New York Convention is a treaty which allows for the seamless enforcement of arbitration awards with very limited grounds for setting aside those awards. Under the New York Convention, the award would have the same force as judgments of the local court. So in Myanmar, it would have the same force as a judgment of the Myanmar court. So this is now part of Myanmar law. The Myanmar Arbitration Act adopts, I believe it's Article 35, 36 of the UNCITRAL model law, which, again, if you read that, will allow for the enforcement of a foreign arbitration award, effectively as if it is the judgment of a Myanmar court. What's interesting about the Myanmar Arbitration Act, though, is there is a slight deviation from the UNCITRAL model law standard, which allows for a grounds for setting aside an award if it's contrary to what's called national interests. Usually that provision is based on public policy, but the wording in the Myanmar legislation is certainly the English translation is national interest. Nobody knows what that means yet. It's too early to tell. But to come back to your question, is it now easier to enforce arbitration awards in Myanmar after the change? Legally, yes, it is. Practically, we're yet to find out.